Good afternoon. The Public Safety Committee will now come to order. Madam Clerk, will you please call the roll?
Alderman Oldenburg,
Present.
Alderwoman Clark Hubbard,
Here.
Alderwoman Keys, Alderwoman Velasquez, Alderwoman Sanye, Alderman Aldrich, Chair Narayan,
Here.
Alderwoman Keys, Alderwoman Velasquez, Alderwoman Sanye, Alderman Aldrich. 3 present. We do not have a quorum.
All right. Thank you, Madam Clerk. Today, my understanding is that the Alderwoman is not looking to have a vote on Board Bill 80, but simply wants to discuss it. So we will skip approving the minutes, and we won't need to excuse any Alder people since we do not have quorum, but we can go ahead and begin the discussion on Board Bill 80, as I know that she wanted to get some things just out and on people's minds before we're done on break.
Thank you, Mr. Chair, members of the committee who we can see online. Thank you for being here today. And look, this is an important issue. I'd be happy to take a vote at any time on it. But given recommendations to just have a hearing as a first step and have some public discourse on the issue, I'm happy to oblige, especially considering we don't have quorum here today. But I do appreciate those members that took the time, especially during this beginning of our holiday season, to tune in here today. Board Bill 80 is a board bill that addresses one of the most important issues affecting the city of St. Louis right now, and that is reckless driving. We have heard it from our constituents, we've all seen it, and we've all frankly experienced it on at this point, more than once a day basis. Just driving here today, I was taken over by people, a carload of people, driving their vehicle essentially as though it were a weapon, because let's face it, vehicles are killing people in our streets. In fact, we had 223 people injured while walking, injured by a vehicle last year, according to TrailNet in the city of St. Louis. And the vast majority of these injuries and many of the fatalities are occurring in low-income communities, communities that are lacking infrastructure and other resources. And so what Board Bill number 80 does is gives us some additional tools to address reckless driving. At first, recognizes that I'll say first and foremost that we had a bill earlier this session that took a bite at this apple, hearing pushback from this other members of the Board of Aldermen about how to grant authority to our police department. What we did was we went back and took a look at what other cities across the country and particularly across the state of Missouri are doing. And across the pond, so to speak, in Kansas City, they implemented a bill very similar to this bill. In fact, this bill was modeled after that bill, which clearly defines the type of driving that that we're trying to address. We have used the definition of street takeover, which is clearly defined in the bill, by identifying specific types of driving that are exceptionally dangerous. It also, in clearly defining that, very specifically defines what our police department has the authority to do right now. We know our police officers, and we have Major Marisi here today over traffic to talk about some of the good work that our police department is doing, issuing tickets, pulling people over, and of course, recognizing that Valentine's law at the state level has made it a felony to flee from police, which is helping us to be able to pull people over more effectively. But what this bill does, in addition to that, is empower our police officers in the case of exceptional reckless driving when a vehicle is used as a weapon to be able to impound a vehicle. And why this is important is because it immediately arrests the reckless driving behavior. It immediately removes that vehicle, that weapon, from our street. And it immediately creates a disincentive more significant than a ticket to driving a vehicle in a way that can kill people. And so with this board bill, what we would do is set the message that we take reckless driving seriously, and we're willing to take action and remove those weapons of vehicular destruction from our street. So with that, Mr. Chair, I did have a member of the public, Attorney Joe Taylor, who helped do research on the bill that would be available for questions, or if you want to make a remark or two. But more importantly, I think to be able to answer questions, and I know you had Major Marisi here, as well as I think some members of the public.
Great. Mr. Taylor, was it? Do you have anything that you'd like to add at this point?
Thanks for hearing me. Yes, I
First, if you could just state your name for the record, and if you could raise your right hand. Do you swear or affirm the testimony that you're about to give is true to the best of your ability?
Yes, my name is Joseph Taylor. I'm a lawyer. My office has been in the city for 30 years. Like all of us, I have seen the behaviors of people with cars, and I think that the reason that I brought this up and wanted to have a specific ordinance on it is to just send the message to the public, hey, we are focusing on this particular type of behavior. There's already a reckless driving ordinance out there. There's also criminal charges that can be brought in if, thank you. Criminal charges that can be brought if someone is injured, or if, of course, if they run from the police when the police try to stop them. But this gives additional action in saying, hey, we're gonna impound the car, and we're gonna treat it as contraband, and we're gonna remove it from the street. And it just tells the public that we're taking a particular focus on this behavior. You can get on any social media site and see the instances of people taking over intersections and doing incredibly dangerous stunts with their cars, people being hurt who are there voluntarily oftentimes, but it's a crazy behavior, and I think it needs to be highlighted that we're focusing, as a city, we're focusing on that. So that's why how this originated. So if you have any questions.
Definitely. I'll open it up to members of the community, or excuse me, members of the committee. Alderman Oldenburg, do you have any questions?
I do. Thank you, Mr. Chair. Just quickly, is the innovation here, the distinction between a reckless driving charge that exists currently and what this is proposing is impoundment?
It's the biggest difference, and it also specifically, I think the prior bill that was introduced tried to define reckless driving as what we see specifically when people are racing through a red light at high speeds, not looking. You can tell it. There's a smell test you can apply, I think, in those situations when you see people just don't have any care at all for what they're doing and how they're endangering people. This one focused a little bit more on street racing, these takeovers, the donuts, the folks who are on the four-wheelers, who are flying through intersections and parking lots, to highlight, hey, we have a general reckless driving ordinance already. We are going to focus this one even more narrowly on these specific types of drivers, and we're going to take your vehicle. Doesn't mean we're going to permanently seize it and you're never going to get it back, but you have to go through the process of the criminal process to get it back.
Okay, and is that specific activity that the bill is tailored toward, are there defined terms of that, or is it in the discretion of either the police officer or the municipal judge to say that this was this certain kind of class of reckless driving?
Each type of behavior is very specifically defined.
Okay.
It's
Thank
in-
you. I haven't had a
it's in the
chance to
bill.
read it, but
No, that's fine.
I certainly will. And I appreciate that.
Okay.
Okay. No further questions at the moment. Thank you, Mr. Chair.
Definitely. And Alderwoman Clark Hubbard, any questions from you?
The only question I had, Alderman Oldenburg just touched on so far. I do want to say it's good to see you, Mr. Taylor. Thank you for being here and for your continued push on platforms like this for some of these common sense innovations, as Alderman Oldenburg put it.
Thank you. It's good to see you as well.
I don't have any particular questions. I would like to hear from, are you going to be sticking around for?
I'll be here.
Yeah, I would like to hear from the police because I may have more questions after that. I don't know. But thank you.
Yeah, I'll be here.
Oh, I didn't see Alderman Aldridge on the call. Alderman, please proceed.
Yeah, I mean, I was going to wait once you kind of skipped me, Mr. Chair, but no, I'm just messing with you. To follow up on Alderman Oldenburg's question. So once the car, I guess, is impounded and the person gets a citation, is it that they can't get their car back until they go to court and there's a judgment made from the judge on the ruling of this new kind of reckless driving charge?
I think more likely it requires that you're going to have to show up in court, which I think we all see a lot of times on municipal charges. Folks don't show up. And I think to get the car back, you're going to have to make an appearance before the court, have the judge hear your case and deal with it. And then, but it's not a seizure of the car. It is impounding it at the point of it's being treated as contraband. It's still a dangerous weapon the way that the vehicle has been used. So we're holding it until a court can determine, A, was there probable cause, and then, B, resolve the case. So that's what I think we're looking at.
Okay, and I guess if they were found guilty for street takeover, then do they not get the car back?
No, they'll still get the car back. I don't think that's something that we can do legally. Permanently seize the car. That would take a little bit more research, and it would probably be subject to a lot more scrutiny in the courts if we tried to simply take the car and seize it. But for purposes of, hey, knowing that it's in a safe place until this court hearing has been held and determinations are made by the court, then that's sort of the purpose, is, hey, let's an immediate cool down phase until.
Is there any thought that, say, if a 17-year-old takes his mom's car out for the weekend and, is doing these things that is not proper, that clearly a citation is issued and the young person would have to go to court, but is there any method built in, and I'm looking over the legislation, built in that the parent can then get their car back before the court to access their vehicle?
There are tools there that if the car is not yours, or if not the driver's, if it's for instance a rental car, or if are not, if the owner is not the one driving it recklessly, there's a process for you to come and get your car. And in fact, fines, especially if the car is stolen, there's no fines, no tow charges, no nothing. You just prove ownership and you take it back. As if you've loaned the car to someone, I haven't read the bill in the last couple hours. I think that there's a way, if it's not the driver's car, you can come back and get your car, and there might be just a processing fee.
Okay, I'm looking through the legislation for that, but I'll look through it and listen to the rest of the speakers.
Okay.
I do have one question now that I'm looking at it. Just having spent a little bit of time in traffic court, I know that there's a lot of amended charges going on there. So what would you propose happen when someone ultimately is not found guilty of any of these? If they amend to a non-moving violation, if they, something that would not put points on your license, which municipal courts all over the place do.
So you're talking about amending it to a non-moving violation?
Yes, sir.
Well, I mean, that's still the discretion of the authorities within the, prosecutor's office with each municipality in the city. But I think, and what we would hope is that they would take this type of driving violation more seriously and not just amend, like you might, a 5-mile-an-hour over speeding ticket to an illegal parking. What we would hope would be is, a standard that would be set as, hey, if we have the proof, if we have the police officer who can testify, this is what I saw them doing, that they're going to hold them to proof of that and push the case through, because it's got to stop. I mean, it's killing people.
Sure.
Well,
No,
this
I'm just trying to think who would be responsible for the towing fees and the storage costs in the instance that someone either through an amended
Amends it, yep.
or else ultimately they're found to not be liable of the infraction.
So I would imagine that under those circumstances, if if you're amending the charge as the city councilor, you could negotiate in terms of saying, hey, we're going to amend it to something less, but you're responsible for towing and storage fees, for one. If you're found not guilty, I think, and again, it doesn't outline it in there, but I would imagine that you're not going to be responsible for those fees because you weren't guilty of the charge being assessed. And so that would be borne by the city, I would imagine.
It almost has, I think right now, has kind of the civil asset forfeiture vibe to it, where even if you're not guilty of the underlying charge, the city still has stuff. And then it's on you to somehow get it back. And I think it's just something that needs to be more fleshed out. That's what we're here in committee.
And so there are cases, there's a case out of New York, there are a few cases that are searched. And we think that this one, obviously we're willing to have input from other, listen, I'm not a traffic law expert. What I try to identify is a problem that we have in the community, and this is one of them, and try to identify ways in which we can deter that behavior. Now, obviously, there's limits to what you can do in deterring people. We have constitutional protections. I think this one probably, because it's a public safety issue, and it's not a fine generating issue, that it's a serious public safety issue, that if we treat the car as contraband, that it can be used to harm people again, that we are holding it until we can resolve the case. And I'm absolutely willing to hear anybody who has a legal argument under the Fourth Amendment, searches and seizures, and maybe this can be tweaked to fit that. But I do know that, for instance, contraband, generally speaking, can be taken as part of a criminal arrest, just like a gun. If a gun is being used, you don't just say, oh, here, it's contraband. Drugs are taken as contraband.
Sure, and I guess my underlying question there, if a gun is taken pursuant to an arrest and a person's found not guilty, the circuit attorney's office goes, here's your gun back. And
That's right.
There's no charge associated with
Absolutely.
that.
Yeah, absolutely. And so I think that the question would be is, okay, we've got to give them their car back. And maybe there's a vehicle that we can include in the bill in an amendment that says, hey, if you really want to expedite this, you can go in for an expedited hearing to say I'm not guilty, or I'm willing to pay my fine and get my car back. Those are all options that are on the table, I think, but I think initially the purpose is a cool down period and say you're treating this car as a weapon and our community's in danger. So we're not just going to say, well, you can have your aunt come pick it up while we charge you or arrest you for this. No, we're going to impound it. And hopefully just, the message alone helps keep folks who have these incredibly powerful cars that we're seeing everywhere, and even not that powerful, just, driving them all over the place like fiends and saying, hey, okay, we have a new bill. Here's what we're going to be able to do. And you see sometimes when you have a new bill on the books, a new law on the books, that the message gets out. And we've seen a little bit, I think, of that with the open carry ban. You know, I feel like we're seeing less of that because the message got out. And hopefully the same happens here, that we can say, hey, folks, you know, you might get your car stolen. And if you decide that your car's faster than the police, be aware, aggravated fleeing now is a major felony, and these guys catch you. They will get you. And it's a major felony. So we're highlighting that in the bill as well, just saying, here's the message we're sending to folks. You know, it's time to stop this behavior.
Understood. With that, unless the sponsor has anything more, I'd like to hear from the police department.
Thank you. Appreciate it.
Absolutely.
Thank you. Thank you, Mr. Chair. You know, I just wanted to acknowledge the question from the Alderman of the 14th, Section 2, subsection B, and then 3. Within that, when a person cited for an alleged violation of the ordinance is not the registered owner of the motor vehicle and the vehicle is impounded within 7 days of the issuance of the citation, the city shall notify the registered owner by certified mail upon and then with instructions on how the registered owner may recover the motor vehicle. But again, with the, I would say, the comparing it to a weapon. I mean, with this bill, we are clearly defining the operation of a vehicle as though it is a weapon and it can kill people. And it is, and vehicles are killing people in our city on a regular basis. You know, when a weapon is used, you know, and the police department seizes that, whether it belongs to the person that's holding it or not, it is still seized as evidence. And it should be, because it is used in a criminal manner. And I would argue the same is true of a vehicle, can be true of a vehicle then operated in a way clearly defined by this ordinance. And so I just wanted to be respectful of the Alderman of the 14th and answer that question before to our police department, Major Marisi.
Thank you. Major, whenever you're ready.
Good afternoon, everyone.
Good afternoon.
Today, I'd just like to provide a little bit of insight as to what the police department
I'm
does.
sorry, could you introduce yourself for the public? Name, please?
Major Joe Marisi. I'd like to provide a little bit of insight to as far as how the police department addresses reckless driving, along with the slideshows. First off, every officer on the department, if they see careless and reckless driving, they'll address it within their district. And I have some numbers as far as tickets that we've written. In 2023, the department as a whole wrote 32,662 tickets. And so far this year for 24, we've written 25,433 tickets throughout the city of St. Louis. And we understand by going through community meetings and talking to the public that this is a big thing that we need to address. And a lot of times when I was the commander of District 3, I would utilize those meetings and talking with the citizens to see where I deployed my officers, where the careless and reckless driving was happening in the times of day and things like that. But it seems like these slideshows are predominantly occurring downtown. A lot of times with these videos, and they're putting the video, they want to see the arch in the background, they want to see downtown, they want to see Busch Stadium within these. So we have a weekend detail that is extra staff downtown, and that detail is led by a night staff commander, which is either a major or a lieutenant colonel, that runs that weekend detail. And we also have tow trucks assigned to that detail. So a lot of times we can strategically place our officers in positions to where the slideshows have happened before, to where we deter it. We also have our intelligence division. They're going out and they're scouring social media for these events. And what they do is they'll go find out who the promoter is to these events. We'll go to their house, we'll talk to them, and we'll tell them that their criminal activity isn't going to be tolerated in the city. We know that they're coming and that we're prepared for them. So a lot of times they'll cancel their event within the city. As far as our procedures, we do a lot when we do these particular stops. A lot of times these vehicles will run from us. So we have the charge of felony fleeing, along with the careless and reckless that we observed at the beginning. So due to the fact of this elevated concern for the city, we do charge state misdemeanor and state felony charges on these cases. And with our new relationship with the circuit attorney, we've had great success as far as getting these cases issued against the offenders. And in these cases, we do tow their vehicles, especially on the detail. We have those tow trucks provided to us for the detail, so we utilize them as much as we can. But sometimes in the districts, if they get a careless and reckless driver that pulls over, could be issued a ticket. It's all up to officer discretion, and each case is taken a little bit differently. They're offered a tow option, which their vehicle can be either towed from the scene, it can remain at the scene, or they can have someone come and pick it up. But that was when we use the ordinance and they're not being arrested for the violation. But if it's an egregious violation and it is a definite careless and reckless, we do tow the vehicle when we do place them under arrest. So each incident in that careless and reckless is a little bit different pertaining on the surrounding circumstances and officer discretion. And you guys have any questions?
I will open it up to the committee. Alderman Oldenburg, any questions for the major?
I don't. Thank you for coming in, Major.
You're
Appreciate
very
it.
welcome. Good to see you.
Alderwoman Clark Hubbard?
Thank you so much for being here, Major Marisi. When you do shut the slideshows down, so how would that look if this law would be in place? What would be different in how you are able to respond to them now versus if this law were to go into?
It wouldn't change anything as far as how we enforce. We would still stop the cars. It would just, it would be another option. But a lot of times we want to, instead of an ordinance violation, we'd much rather go with the state misdemeanor or the state felony charge because there's more of a consequence to their action. So we would go more towards that.
Okay. All right, and I did hear you say about the tow trucks are already in place, so that was another thing that made me flag or what would be a difference in it. But thank you for making that clarification on that. That makes sense as well.
You're very welcome.
Do you have anything further, Alderwoman?
No, just appreciate you being here today.
And then Alderman Aldridge, any questions for the major?
No, thank you, Mr. Chair, and thank you, Major, for being here. Alderwoman Clark Hubbard asked the same question that I had. What is the difference between the current tools in your toolbox already that you guys have with reckless driving, and what would this kind of do as a difference? But it sounds like even with the reckless driving tools that you guys already have, you still go a little beyond that. We're trying to use some harsher penalties that the state allows you guys to do. So no question, just appreciate you being here.
Thank you, sir.
And likewise, I appreciate being here. I also, I had no idea that the number of tickets that you guys wrote in the last couple of years was so high. So cars are currently being towed, and we are seeing the state charges come through.
Yes, with our better relationship with the circuit attorney, we have seen they're entertaining those cases much better, and we're getting warrants issued, and that person is being held accountable much more than they have been in the past.
Okay. Well, thank you so much. That's all I have.
Thank you.
Thank you. Alderwoman?
Thank you, Mr. Chair, and thank you so much, Major Marisi. I'm grateful that you're over our traffic division now. You did a great job in the 3rd District for many. But look, I want to talk about the difference here. As the Major pointed out, the officers are right now giving the folks involved the option of a tow. Okay, but what this ordinance does is it takes that choice out of the hands of the folks that are operating their vehicles like a weapon. Okay, and giving them the option of a tow is what we're currently doing. And while we're making some headway, the general public is demanding that we take action. Okay, I know they're demanding it of me, and I know that they're demanding it of my colleagues down here. And I think we should. I think we should give our police department more tools action. There's nothing prohibiting not only state charges, but a municipal ordinance violation as on top of it that would empower our police department at their discretion, not at the discretion of the person operating the vehicle, but at the discretion of the police officer to impound the vehicle, to impound the weapon that is being used to put lives in danger on a regular basis. And so that is what this bill would allow us to do. It's been very effective at curbing the behavior in Kansas City. And much like the gun bill that we passed earlier this year, last year, just the threat of it, just the threat of being able to take the weapon of a child who's openly carrying a weapon has majorly reduced that very, very, very dangerous behavior. And the chief has even said that it's reduced gun violence in the youth population by 50%. Just the threat of taking the weapon has been very effective. And I would argue that this bill could have the same impact. The threat of impounding a vehicle can and should greatly reduce that exceptionally dangerous behavior. And look, I'm not here to come down on people that are recklessly driving. I lost my sister recklessly driving. I'm not here to punish those people. I'm here to stop the behavior. And that's what I think we as a city should be focusing on doing, and that's what Board Bill number 80 would do. So, Mr. Chair, I really appreciate you calling this hearing over the break, or the beginning of the break. We're not officially on break yet, and to members of our staff who were here today to hear it. It's the beginning of a discussion. I ask members of the committee, I want to thank you all for tuning in. I know many of you couldn't be here in person today, but I appreciate you spending your time hearing this issue and hearing this proposal. And I would ask that any comments or concerns or suggestions for changing the bill for the better be submitted. I know when we consider the gun bill, hearing members of the committee weigh in and give constructive feedback was a path to making that bill better. And I have no doubt we could do the same here with this one.
With that, I do have a couple questions for you that you and
Major Maurice.
no, the attorney,
Attorney Joe Taylor, sure.
had brought up. Sorry, I was curious if in your initial discussions and research, one of the things that you had brought up just a minute ago was maybe an expedited hearing at the municipal court. Is that something that you've talked to anyone over there about?
I have not talked specifically, but I'm very open to it. I like the idea. I would definitely be willing to have those conversations, Alderman, and see what we can do there. I think it's for the concept and a path to having some fairness on all sides here.
I appreciate that. And then what considerations, because when I'm just kind of weighing these two things, what consideration did you give to just overall hardship? Because I'm thinking about kind of a situation like what the Alderman 14th brought up, where maybe you have a kid who goes and spins his tires, a little bit too much at a stoplight, and this comes into play, but now dad can't get to work. And that could create a much larger issue. And I know that that's not what you're intending to do with this. So I'm just curious, what, if any, considerations you had regarding that through this process, just try and police for that at all?
Look, I mean, what do you say to a kid who is using their dad's weapon and killed somebody?
But their dad probably doesn't need that weapon to put food on the table for the family or to pay the rent.
No, I'm talking about a dad whose kid uses the vehicle and kills somebody. I'm not talking about, we have what I would consider a reckless driving crisis on our hands. A crisis. And we have to take action. I see no path forward but to get serious about this. And if that means every parent that has a vehicle is going to have to come down and say, look, you can't drive my car or anybody else's car this way. As far as hardship goes, I'm open to ideas, and I'm open to, we had talked to Bi-State about potentially offering free transit vouchers for that, and I'm open to those concepts. I will say as well, it clearly states in the ordinance that if it's not your vehicle, path, I would be absolutely open to expediting that specifically for that case that you described. We're not here to punish people necessarily, but at the end of the day, what we're doing, while we're making strides, and I'm grateful to hear that we're issuing tickets, but it isn't working. It is dangerous to be a pedestrian. It's dangerous to ride a bike. It's dangerous to drive another vehicle in this city. And I do think we have got to put harsher consequences in place one way or the other, or we're not going to be able to curb this behavior. Speed bumps are not cutting it. Bump outs are not cutting it. There's no amount of infrastructure that's going to prevent this kind of behavior, and we have to do something to save our citizens. So I am definitely open to that. Alderman, if you have ideas, I want to hear them and we'll try to implement them. I will say that's where if it's not your vehicle, but if you are operating a vehicle like a weapon is your vehicle, I have no sympathy for you.
Sure. And no, I think the hardship angle, I think an expedited hearing, or a chance to, if your dad and your kid was driving it, or mom and your kid was driving it, the chance to say, because in this it says the city shall notify you within 7 days, and that's great. But if kid notifies you that night, it'd be ideal if you could come, the next morning. And
Sure. Well, I'll tell you, I think you bring up a point that's worthy of consideration. And again, it's, punishment isn't the goal here. It's to curb the behavior, but and the threat of punishment isn't effective there. But considering that, I think would be worthwhile to talk to the courts and see if we can get a path to expediting those types of hearings for that specific reason. I'll work over the break to try to identify that.
And I'm happy to work with you on that front as well.
I appreciate that. That would be very helpful and much appreciated.
Is there anything further that you'd like to? Oh, I guess I'll see if any of the rest of the committee has any. I kind of jumped the line there. See if anyone else has anything for you. Alderman Oldenburg?
Nothing further, thanks.
All right. Alderwoman Clark Hubbard?
Not at this time, thank you.
All right. And Alderman Aldridge?
Nope, not right now, thanks.
All right. Perfect. Well, with that, I guess we'll just keep this discussion going, and we don't have to excuse anyone because we, no, we did have quorum.
You have
Yeah, we do
quorum,
have
but you
quorum.
don't have.
So,
Alderwoman Keys did call and say she wouldn't be able to make it today.
okay, with that, I will entertain a motion to excuse Alderwoman Keys, Alderwoman Velasquez, and Alderwoman Saunier.
So moved.
Second.
All in favor signify by saying aye.
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 And I'll also entertain a motion to approve the minutes of Wednesday, December 11th and Thursday, December 12th.
We didn't have a quorum
So move.
We didn't have a quorum.
Second.
For what?
to approve the minutes.
We have a quorum
have a
now.
quorum now.
Alderman Aldrich is here.
We have a quorum now. So I'm sorry, who made that motion?
Second.
So it was Oldenburg who made the motion and Aldridge who seconded it. All in favor signify by saying aye.
Aye.
Opposed? All right, with that, we've approved the minutes, and I will entertain a motion to adjourn.
So move.
Second.
All in favor signify by saying aye.
Aye.
We stand adjourned.